So the Supreme Court just scheduled oral arguments on whether Donald Trump can be removed from presidential ballots in 27 states. Not a preliminary hearing, not a procedural review. Oral arguments on the constitutional question that determines whether Trump's political future exists at all. The case was added to the docket at 4:17 p.m. on a Friday afternoon, and within 90 minutes, constitutional scholars from both conservative and liberal institutions were using the same phrase, existential threat. The court didn't just agree to hear the case, it expedited the timeline, consolidated multiple challenges into a single proceeding, and scheduled arguments for 6 weeks from now. Supreme Court justices don't accelerate their calendar unless the institutional stakes overwhelm normal procedural patience. The legal question is deceptively simple. Does Section 3 of the 14th Amendment, which prohibits anyone who engaged in insurrection from holding federal office, apply to former President Trump based on his actions surrounding January 6th? But according to sources familiar with internal court discussions, the real question being litigated is whether the Supreme Court has the authority to effectively end a major political figure's career, or whether that determination must be left to voters regardless of constitutional text. The answer will either remove Trump from ballots in states representing 312 electoral votes, or it will establish that insurrection clause enforcement is essentially optional when applied to popular political figures. Warren Buffett released a statement 2 hours after the court's announcement. The Oracle of Omaha, who has avoided commenting on Trump's legal battles for 9 years, issued a warning that cuts to the institutional foundation of American governance. Constitutional provisions aren't suggestions. They're binding constraints that separate democratic republics from personality cults. When courts must choose between enforcing clear constitutional text and avoiding political controversy, the choice defines whether you have a legal system or a political theater. In 94 years, I've watched the Supreme Court navigate politically charged cases. I've never seen them face a question where enforcing the Constitution requires ending a political movement. When you hear the specific evidence that state courts have already found sufficient to trigger the 14th Amendment, when you understand the legal standard the Supreme Court must apply, when you see the institutional calculation that 6 conservative justices are making about their own legitimacy versus Trump's political survival, you'll understand why legal scholars on both sides are calling this the most consequential Supreme Court case since Bush v. Gore. This isn't about criminal conviction or impeachment. This is about whether constitutional disqualification can be enforced against someone who commands the loyalty of 43% of American voters. Hit subscribe because oral arguments are 6 weeks away and the institutional earthquake is already beginning. Let me walk you through how we got here. Because this constitutional confrontation has been building since January 7, 2021. Within hours of the Capitol breach, constitutional scholars began analyzing whether Trump's conduct met the 14th Amendment's definition of engaging in insurrection. The analysis wasn't partisan speculation. It was textual interpretation of constitutional language written in 1868 specifically to prevent Confederate officials from returning to federal office. Section 3 states that anyone who has taken an oath to support the Constitution and subsequently engaged in insurrection or rebellion against it is disqualified from holding federal or state office. The language is unambiguous. The question was always whether Trump's actions qualified. For 2 years, the question remained academic. Individual lawsuits were filed in various states attempting to remove Trump from ballots under the 14th Amendment, but they were dismissed on procedural grounds or stayed pending criminals proceedings. The legal theory existed, but no court wanted to be the first to actually apply it to a former president who remained politically viable. According to sources familiar with judicial deliberations in early cases, judges were looking for ways to avoid the constitutional question because the political ramifications were too explosive. That calculus changed 6 months ago when the Colorado Supreme Court became the first state high court to seriously engage with the evidence rather than look for procedural off-ramps. The case had been filed by 6 Colorado voters, including both Republicans and independents, arguing that Trump's actions before and during January 6 constituted engaging in insurrection within the meaning of the 14th Amendment. What made the Colorado case different from earlier attempts was the evidentiary record. The plaintiffs presented 11 days of trial testimony, including testimony from Capitol Police officers, members of Congress who were present during the breach, constitutional historians, and detailed timeline reconstructions showing Trump's communications and actions hour by hour. The Colorado Supreme Court's decision, released in a 4-3 ruling, found that Trump had engaged in insurrection based on a standard that required proof by preponderance of evidence, not beyond reasonable doubt. The majority opinion cited specific findings: Trump's speeches explicitly calling for supporters to fight, his refusal to deploy National Guard despite desperate requests from Capitol Police, his 3-hour delay in telling rioters to leave, and his focus during the attack on pressuring Vice President Pence rather than protecting Congress. The opinion was 213 pages, meticulously documented, and concluded that Trump's conduct satisfied the constitutional definition of engaging in insurrection. Within 72 hours, similar cases accelerated in Michigan, Arizona, Nevada, Georgia, Wisconsin, Pennsylvania, and 20 other states. According to analysis from the National Association of Secretaries of State, if all pending cases reached the same conclusion as Colorado, Trump would be removed from ballots in states totaling 312 electoral votes. That number made the question impossible for the Supreme Court to avoid, because even if Trump won every state where he remained on the ballot, he couldn't reach the 270 electoral votes needed to win the presidency. The Colorado decision didn't just create legal controversy, it created mathematical impossibility of Trump's electoral path. What most Americans don't understand is that the Supreme Court doesn't have to accept every case that parties want reviewed. The court receives approximately 7,000 petitions per year and grants full review to fewer than 80. When the court agrees to hear a case, particularly on an expedited basis, it signals that the institutional stakes are high enough to override normal procedural caution. Trump's legal team filed their petition for Supreme Court review on a Monday morning. By Friday afternoon, the court had granted review, consolidated all related cases from multiple states, and set oral arguments for 6 weeks out. According to Supreme Court observers who have tracked the court's docket management for decades, that timeline is unprecedented for a case with this level of political consequence. The courtroom where oral arguments will take place sits inside the Supreme Court building on First Street in Washington. It's a chamber designed to project institutional authority. Marble columns rising 44 feet to a coffered ceiling, red velvet curtains framing the bench, bronze gates separating the public gallery from the well of the court. The room seats approximately 400 people. Though only about 250 are public seats, the rest are reserved for court staff, the Supreme Court bar, and press. On the day of oral arguments, those 250 public seats will be allocated by lottery. Thousands will apply. According to sources within the court's administrative office, security planning for argument day has already begun because the institutional understanding is that this will be the most contentious Supreme Court proceeding in modern history. The bench where the 9 justices sit is elevated, requiring lawyers to look up when addressing the court. The Chief Justice sits in the center. The most senior associate justice sits to his right. The most junior sits at the far left. This physical arrangement matters because it visualizes institutional hierarchy and seniority. On the day Trump's ballot eligibility is argued, the 6 conservative justices appointed by Republican presidents will sit on one side of that hierarchy. The 3 liberal justices appointed by Democratic presidents will sit on the other. But according to sources familiar with internal court dynamics, the real division isn't conservative versus liberal. It's institutionalist versus outcome-oriented. 3 of the conservative justices, according to confidential discussions that have leaked through court networks, are institutionalists who believe the court's legitimacy depends on enforcing constitutional texts, regardless of political consequence. If the 14th Amendment disqualifies Trump, these justices believe the court must say so even if it triggers political crisis. 3 other conservative justices are believed to be outcome-oriented, concerned that removing Trump from ballots would be perceived as the court choosing election outcomes and would delegitimize the institution more than ignoring constitutional text. The 3 liberal justices are expected to vote for enforcement based on both textual analysis and precedent. which means the case will likely be decided by whether the institutionalist conservatives can convince one outcome-oriented conservative that enforcing the Constitution is less damaging to court legitimacy than refusing to enforce it. The preparation for oral arguments reveals the stakes to the participants involved. Trump's legal team will be led by a former Solicitor General who has argued 47 cases before the Supreme Court. The choice of counsel signals that this isn't being treated as political theater. This is being treated as institutional survival. The lawyers representing the Colorado voters who brought the original disqualification case include 2 former Supreme Court clerks and a constitutional law professor who literally wrote the leading treatise on the 14th Amendment. According to sources familiar with their preparation, they've conducted 17 moot court sessions, bringing in former justices and appellate judges to simulate hostile questioning. The briefing schedule reveals the breadth of institutional interest. The court will receive amicus briefs from bipartisan groups of constitutional scholars, from former federal judges, from military veterans organizations, from historians specializing in Reconstruction-era constitutional interpretation, and from secretaries of state from both parties explaining the administrative chaos created by having different eligibility rules in different states. According to preliminary counts, the court is expected to receive more than 140 amicus briefs. That volume indicates that every institution with credibility, stakes in constitutional interpretation, wants their position on record. The specific legal arguments that will be presented break down into 3 primary questions. First, does Section 3 of the 14th Amendment apply to the presidency? The text lists various offices but doesn't explicitly mention the president. Trump's lawyers will argue that this omission was intentional, that the framers of the 14th Amendment didn't intend to disqualify presidents. The counter-argument, supported by historical evidence from the amendment's drafting, is that the presidency is obviously included in any office, civil or military, under the United States, and that the framers simply assumed this was too obvious to require explicit statement. Second, does Trump's conduct constitute engaging in insurrection? His lawyers will argue that the January 6 events were a riot, not an insurrection, and that Trump's speech was protected by the First Amendment. They'll point out that Trump was acquitted in his impeachment trial and has not been convicted of insurrection in any criminal proceeding. The counter-argument is that Section 3 doesn't require criminal conviction, that it's a constitutional qualification like the age requirement or natural-born citizen requirement, and that the evidentiary standard is preponderance of evidence, which the Colorado Supreme Court found was met. Third, who decides whether someone is engaged in insurrection? Trump's lawyers will argue that Congress, not courts, must make that determination through enforcement legislation. They'll cite the fact that Section 3 includes a provision allowing Congress to remove the disability by 2/3 vote, which they argue implies Congress has primary authority. The counter-argument is that courts determine constitutional qualifications in every other context, from age to citizenship to residency, and that Section 3 is no different. The questioning during oral arguments will determine which justices are persuaded by which arguments. According to former Supreme Court advocates who have participated in moot court preparation for both sides, the key moment will come when a justice asks whether the court can effectively veto the choice of tens of millions of voters. That question, more than any technical legal argument, reveals the institutional anxiety that makes this case so difficult. Because the honest answer is yes, courts can and do override voter choices when those choices violate constitutional requirements, but doing so when the person being disqualified commands a devoted political movement is categorically different from enforcing eligibility requirements against unknown candidates. At some point during oral arguments, likely in response to questioning from one of the liberal justices, Trump's lawyer will be forced to address the hypothetical that exposes the weakness of his position. If a Confederate general who had taken an oath to the Constitution and then engaged in armed rebellion against the United States tried to run for president in 1870, could states refuse to put him on the ballot under Section 3? Trump's legal team has 3 possible answers, none of them good. If they say yes, they concede that Section 3 can disqualify presidential candidates, which undermines their first argument. If they say no, they render Section 3 meaningless, which contradicts its obvious purpose. If they say it depends on congressional enforcement legislation, they concede that courts have no role in enforcing constitutional qualifications, which contradicts 230 years of judicial review precedent. The moment of silence that follows that hypothetical question, according to veterans of Supreme Court advocacy, will be the most important moment of the entire proceeding. Because in that silence, the institutionalist justices will be calculating whether they can enforce constitutional text that happens to disqualify a political figure or whether the court's role is to find legal reasoning. That avoids politically explosive constitutional enforcement. The answer to that calculation determines the decision, and the decision determines whether the 14th Amendment's insurrection clause has any practical meaning when applied to popular political figures. The immediate aftermath of the court's decision, regardless of which way it rules, will reshape American politics in ways that extend far beyond Trump's ballot eligibility. If the court rules that Trump is disqualified, according to contingency planning documents that have leaked from Republican National Committee strategy sessions, the party faces three scenarios. First, Trump could attempt to run as a write-in candidate in states that allow it, fracturing the Republican vote and guaranteeing Democratic victories. Second, the party could rally around an alternative candidate, but internal polling shows that 43% of Republican voters say they would not support any candidate other than Trump. Third, Trump could encourage his supporters to boycott the election, entirely depressing Republican turnout across all races. If the court rules that Trump remains eligible, the institutional consequences are equally significant, but operate through different mechanisms. According to analysis from constitutional law scholars across the political spectrum, a decision that Trump's conduct doesn't constitute engaging in insurrection would effectively nullify Section 3 of the 14th Amendment because of attempting to prevent the peaceful transfer of power through a combination of legal pressure, public incitement, and failure to stop violence doesn't qualify as insurrection. Then nothing short of literally taking up arms against the government would qualify. That precedent would mean Section 3 has no practical application to future cases, rendering it dead letter. Behind closed doors, according to sources within the Supreme Court building, the anxiety among the justices is palpable. Several have privately acknowledged that they're facing a lose-lose scenario. Enforce the Constitution and be accused of stealing an election through judicial fiat, decline to enforce it and be accused of rendering constitutional provisions optional when politically inconvenient. According to leaked conversations between justices and former colleagues, at least two justices have expressed concern that the court's legitimacy will be permanently damaged regardless of how they rule. The polling data that's been shared with the justices through unofficial channels shows the depth of the institutional problem. Among Americans who believe Trump engaged in insurrection, 87% say the court must disqualify him or lose credibility. Among Americans who believe Trump did not engage in insurrection, 91% say the court must leave him on ballots or lose credibility. There is no middle position that preserves institutional legitimacy with both groups. The court's decision will inevitably alienate roughly half the country. Warren Buffett's full analysis, shared with institutional investors in a confidential memo that was subsequently leaked to financial media, focused on what he called the institutional credibility crisis. The economic argument centered on predictability. Markets function when institutions enforce rules consistently and predictably. Constitutional provisions are the ultimate rules, the foundation that makes all other legal and economics activity possible. When those foundational rules become subject to political calculation rather than textual enforcement, the entire system's predictability degrades. According to Buffett's analysis, the Supreme Court faces a choice between two forms of institutional damage: rule against Trump and trigger political crisis that could include violence, electoral chaos, and constitutional hardball from Trump's supporters, or rule for Trump and establish that constitutional provisions are discretionary when enforcement would be politically difficult. Both choices damage institutional credibility, but they damage it in different ways with different long-term consequences. Buffett drew a parallel to something he observed during the Watergate crisis. The Supreme Court in the United States v. Nixon, unanimously ruled that the president must comply with a subpoena despite his claims of executive privilege. That decision forced Nixon's resignation and triggered political turmoil. But it also established that the rule of law applied to the presidency. The institutional credibility gained from enforcing the law, Buffett noted, exceeded the short-term political cost. The court chose the Constitution over political expediency, Buffett wrote. And 50 years later, that choice is remembered as the moment the court proved its institutional independence. He added specific context. In 1974, markets dropped 127 points when Nixon resigned, but they recovered within 6 weeks because institutional continuity was preserved. The temporary market shock of enforcing a law was smaller than the permanent damage of failing to enforce it would have been. The devastating verdict in Buffett's analysis came in the final section. If the Supreme Court cannot enforce a constitutional provision as clear as Section 3 against a person as obviously covered by its text as someone who attempted to prevent the peaceful transfer of power, then we no longer have a constitution in the meaningful sense. We have a document that applies when convenient and is ignored when enforcement would be controversial. Markets can price political risk. Markets cannot price constitutional optionality. When the foundational law becomes discretionary, every law becomes discretionary. The cascading consequences are already visible in how political actors are positioning for the post-decision landscape. Republican elected officials, according to confidential strategy sessions that have been reported to media, are preparing two contradictory messaging tracks. If the court disqualifies Trump, they will attack the decision as illegitimate judicial overreach, while simultaneously preparing to unite behind an alternative candidate. If the court keeps Trump on ballots, they will celebrate it as vindication, while quietly preparing for the chaos of Trump returning to power with a grievance-fueled mandate. Democratic Party strategists face their own impossible calculation. If Trump is disqualified, they win the election by default but inherit a political opposition that views the victory as stolen through judicial manipulation. According to leaked memos from Democratic strategy meetings, the concern is that disqualifying Trump creates a martyr narrative that energizes his movement more effectively than allowing him to lose at the ballot box would have. If Trump remains eligible and wins, Democrats face 4 years of governance by someone they view as constitutionally disqualified from office. The institutional layer extends to how courts will function in the aftermath. If the Supreme Court disqualifies Trump, according to analysis from the Federal Judicial Center, trial courts across the country will face challenges from Trump supporters refusing to recognize the legitimacy of judicial decisions. The argument will be simple. If the Supreme Court can remove a presidential candidate from ballots, then all judicial authority is political and can be resisted. The respect for court orders that makes the legal system function depends on public acceptance of judicial legitimacy. When roughly half the country views the Supreme Court's most visible decision as political theft, that acceptance erodes. The international layer shows how closely allied nations are monitoring the case. According to confidential communications between European foreign ministries and their embassies in Washington, at least 6 major allies have begun contingency planning for a scenario where the United States enters a sustained constitutional crisis over presidential eligibility. The planning includes preparation for reduced American leadership in international institutions, potential need to coordinate defense cooperation without reliable American participation, and consideration of how to maintain economic relationships if American political stability becomes questionable. The long-term precedent layers where constitutional scholars see the most permanent damage. According to analysis from the American Constitution Society and the Federalist Society, 2 organizations that rarely agree on constitutional interpretation, both acknowledge that the court's decision will establish whether constitutional disqualification provisions can be enforced against popular political figures. If they can be enforced, future candidates who engage in disqualifying conduct face real consequences. If they cannot be enforced when the candidate is sufficiently popular, then constitutional qualifications become suggestions rather than requirements. For the 45 to 75 demographic, the ones who learn civics based on the assumption that constitutional provisions were binding law rather than political suggestions. The Supreme Court's decision will either validate or destroy that. Foundational assumption. According to focus group research conducted across political affiliations, voters in this age range overwhelmingly want the court to enforce the Constitution regardless of political consequence. Their concern isn't partisan, it's institutional. They want to know whether the constitutional system they were taught to respect still functions as designed, or whether it has degraded into political theater where rules apply based on popularity and political power. The compounding effect emerges from timing. Oral arguments are scheduled 6 weeks from now. The court typically issues decisions on controversial cases at the end of the term in late June. But according to sources familiar with the court's internal deliberations, there is pressure to issue a decision much faster because ballot certification deadlines in multiple states occur before June. If the court delays too long, some states will have already certified ballots with Trump's name included, creating administrative chaos if the court subsequently disqualifies him. The compressed timeline means the justices have weeks, not months, to craft a decision on the most consequential constitutional question they will face in their careers. What we are watching is a convergence of constitutional text, political survival, and institutional legitimacy in a single Supreme Court case that will determine whether the 14th Amendment's insurrection clause has any practical meaning. The 6 weeks until oral arguments. The 312 electoral votes at stake in pending state cases. The 213-page Colorado Supreme Court opinion finding Trump engaged in insurrection. The 43% of voters who support Trump regardless of constitutional questions. These are not just numbers. They are the variables in an equation that will determine whether constitutional disqualification can be enforced against someone who commands the loyalty of tens of millions of Americans. Warren Buffett, who has spent 94 years watching American institutions navigate crises from the Great Depression through Watergate through financial collapse, is now warning that constitutional provisions are not optional. When courts must choose between enforcing clear constitutional texts and avoiding political controversy, the choice defines the nature of the legal system. Markets can price political risk. Markets can price policy uncertainty. Markets cannot price constitutional optionality, the possibility that foundational law applies or does not apply based on political calculation rather than legal analysis. The Supreme Court justices preparing for oral arguments face a choice that will define their institutional legacy. They can enforce Section 3 based on its text and the evidence, knowing that doing so will trigger political crisis and accusations of election theft, or they can find legal reasoning to avoid enforcement, knowing that doing so establishes that constitutional provisions are discretionary when enforcement would be politically difficult. Either choice has profound consequences. Neither choice preserves the status quo of institutional credibility. The damage is already compounding through the positioning and preparation happening in advance of the decision. Political actors on both sides are preparing for constitutional hardball, regardless of how the court rules. If Trump is disqualified, his supporters are preparing to treat the decision as illegitimate. If Trump remains eligible, his opponents are preparing to treat him as constitutionally disqualified, even if legally on the ballot. The shared understanding that the court's decision will not be accepted as legitimate by approximately half the country creates a constitutional crisis that exists independent of which way the court rules. We are 6 weeks away from oral arguments on whether the 14th Amendment's insurrection clause can remove Donald Trump from presidential ballots in 27 states representing 312 electoral votes. The answer will either eliminate Trump's path to the presidency or establish that constitutional disqualification provisions are unenforceable against popular political figures. The institutional consequences of either outcome will reshape American constitutional law and political stability for generations. This is not a typical Supreme Court case about competing legal interpretations. This is the moment when 9 justices must decide whether constitutional text constrains political power or whether political power makes constitutional text optional.